In this video, we discuss 10 things to leave out of your will. Some of these will surprise you. Coming up next on Holy Schmidt.
Holy Schmidt!
Shouldn't everything go in your will because this is the last legal document of your lifetime? Well, the simple answer is no. Here's why. First, let's start off with acknowledging that creating a will is a very important step in the effective management of your estate and making sure that the people you want to be taken care of are in fact taken care of. However, certain things should be excluded due to complications or legal disputes. That is what this video is all about. All right, let's go. But before we do, let me remind you to stick around to the end because there is one state out of the 50 states where a lot of this doesn't apply. And if you live in that state, you'll have to proceed differently. Number one, jointly owned property. When property is jointly owned, there's typically a provision that says that the property is owned with right of survivorship, which means that when one party passes, the other takes full possession of the asset. In this case, a good example would be a husband and wife that owns a home. This type of ownership bypasses the probate process and is not controlled by the terms of the will. Including jointly owned property in your will creates confusion and contradicts the automatic transfer rights that are included in this type of situation. Instead, ensure the joint ownership documentation is clear about what happens when one party passes. Number two, life insurance and retirement accounts. Life insurance and retirement accounts, like a 401k or an IRA, have specific beneficiaries, and those beneficiaries are paid directly upon the departure of the account owner. These assets don't go through probate, and creating a will that has language in it that is different from what is in the policy or the 401k IRA designated beneficiaries creates confusion. And to be super clear, if you have a life insurance policy that designates, say, your child as your beneficiary, no matter what your will says, the policy language will prevail. Number three, instructions for illegal activity. Let me explain. Any provision in your will that designates that your executor or your beneficiaries engage in illegal activity is unenforceable. This means things like trying to disinherit your spouse, even though the state law says that you can't do that, or to hide assets upon your death. Of course, one could get really dramatic here and say leaving money to illegal business activities is also prohibited, but we don't need to go there. Number four, leaving specific personal property is probably best dealt with outside of the will. Let me explain. Leaving your $1.5 million McLaren P1 in your will might not be a bad idea, but if you leave your model McLaren P1, which might be worth $39.95 in the will, well, that's probably best dealt with in a schedule outside of the will. The same thing holds true with things like jewelry, some art, and other personal property that just clog up the will and create animosity amongst the recipients. A specific document called a letter of instruction is probably the best way to go because when you add a lot of small items to the will, it becomes unwieldy. Number five, your funeral instructions. Funeral instructions should be communicated separately to your loved ones because, frankly, by the time they get to reading the will, that decision will already have been made. It's more effective to communicate your wishes in a separate document given directly to the executor of your will so that the outcome is timely and exactly as you want. Number six, conditions on gifts. I call that the if you do this, then you'll get that type of instruction. For example, a beneficiary can only get their inheritance if they go to college. That provision complicates the will and may even be unenforceable if you put it directly in the will. For example, put the funds in a trust with the specific instructions that these are to be distributed only after your grandchild graduates from college. Next, assets that are in a trust should not also be in your will. Including the assets that are in your trust in your will can create complications and undermine the entire purpose of the trust. Instead, ensure that the trust accurately reflects your wishes and leave them out of the will. For example, if your living trust holds your primary residence, you wouldn't want to put that in your will. The trust will govern the distribution of your residence. Next, digital assets and online accounts. Digital assets such as your email, your online banking, or your social media accounts need a separate digital asset estate if you're going to put them in anything at all. The reason is that a will doesn't typically give the instructions on how to access these types of assets, and putting them in a separate discussion document is the easiest way to manage those assets. Creating a separate digital estate plan will help ensure that the executor of the will accesses and manages those assets properly. Next, outright gifts to minors. Giving an outright gift of a large sum of money to a minor creates both logistics and practical problems because minors can't own large sums of money. Instead of giving the gifts outright, consider setting up a trust or a custodian account that holds the assets until the child becomes of age. For example, if you want to leave $50,000 to your grandson or granddaughter, think about setting up a trust for them, because in that instance, that trust can manage the assets until they become 18 or whatever age you designate. Next, specific business interests are often best left outside of the will. For example, if you own a share in a company, that share might be better dealt with what's called a buy-sell agreement with the other owners in the company. And to get really specific here, including your business interests in your will may complicate the issue for your partners, and frankly may put the business in jeopardy if somehow someone decides to take over the company and that's not the person you really want running the company. Just to get really pragmatic here, work with your attorney to execute your business succession plan so that the transfer is orderly and it stays out of your will. Creating a will is a very important part of estate planning, but also knowing what to leave in and what to leave out is supremely important for the successful execution of your wishes. Leaving the items discussed in this video will help create clarity for your loved ones, avoid legal issues, and ensure that your wishes are honored. By carefully considering what to exclude, you can create a much more effective and efficient estate plan. Oh, and what is the state we were talking about? Well, if you live in Washington State, some of the things above actually don't apply. Washington State has enacted a law, it's called the superwill statute, that gives the will more clout than in the other 49 states. The superwill statute of Washington State allows the will to include other non-probate items in the will itself. If you're looking at this video at some point in the future, and I don't know if that's a day, a week, a year, or a decade, check your state to see if a superwill statute has been enacted there. And finally, some additional tips to help you with effective estate planning. Consult an attorney, of course, to verify everything that we talked about here, because things can be different for you and your specific circumstances. Regularly review your will to make sure that it still makes sense, because life changes, and when life changes, things within a will sometimes need to change as well. Next, communicate clearly. Make sure the executor and your loved ones understand exactly what you mean with the items that are in the will and actually the items that are not in the will. Next, consider a trust for more complicated estates. A trust will help deal with some of the more difficult issues that most people don't actually have to deal with, but if you're the type of person that has these issues, it's probably a good thing. By following these guidelines, you can create a will that accurately reflects your wishes and clearly helps support your loved ones. If you like this video, please make sure you click subscribe and turn on notifications so that you get alerted the next time I post a video. I post once or twice a week. Also, if you have Instagram, make sure you follow me on Instagram. My handle is _Schmidt_list. That's _Schmidt_list, and that's on Instagram. If you like this video, check out that video. It's called When is a Retiree Considered Wealthy? This is Jeff Schmidt. Thanks for watching.